first respondent that the High Court had been constant to issue a direction for the accent in the elective after suffering material was placed before indicated that candidate has been prevented from filing their nomination. It was urged as a result of the violent activities of the supporters of the ruling party in the state, a situation had arisen where it was not possible to file nomination paper. Personally, hence the directions which are issued by the High Court subserve the cause of free and election. There the Supreme Court has said, no, we can't interfere at this stage. If you have any grievance, go before the civil court. Under Millard, in this matter, what has happened, since the 30 days have gone, expired statutory, the Supreme Court exercised the power under Article 142 of the Constitution and extended the time for more than another 30 days, go before the civil court. There also same allegation, Supreme Court did not accept that. Millard, I have just seen that. Here in this case, what has happened, Millard, your lordships will, I don't know whether your lordships have gone to the, in other matters, regarding the schedule of this election. Date of nomination, your lordship has seen. Date of, Millard, the filing last. Date of scrutiny, lordship has seen that. Millard, on 17th, on 17 at the time of scrutiny. Millard, if someone was not present, nobody is. Millard,
no, this case is the scrutiny was done.
No, that's exactly I'm saying to your lordship. They are saying it is in the list. Portal, his name is being shown. It is his case. It is his case. Millard, portal and another is not a statutory obligation. This maybe what has happened. I am reading from the order, Millard. I can.
Which order?
Rejection of his nomination on 17th June itself.
Whose rejection?
His case. This
No
Muslima Begum.
But then it has been submitted that no reason has been given for rejection.
No reason has been. He was not there. What can be? She was not there. What can be done? I tell you, Lord, Millard, kindly see. Yes, my lord. If you do not mind, Millard, can I just?
No, just read it out from there.
Hand over laptop, Millard.
No, read it out.
My lord, see. Venu Bhangor 2 meeting hall dated 17 June 23. GAPS constituency name and Bhangor 2 Romantic name of the intending candidate. Muslima Begum, date of submission 15 June 2023. Time of submission 8:01 p.m. Millard, submission was, it was up to 3 p.m. After this, I will tell you, let's say, another incident. 8:01 p.m. Nomination was received on 15 June 2023 at 8:01 p.m., which was beyond the prescribed time for filing nomination as per Form 1, published by the District Panchayat Election District South Panchayat. Moreover, nomination papers were submitted by force under duress when the nomination venue was captured and ransacked by violent and mob carrying arms, rods, sticks and stone. 2. During scrutiny, other candidates raised objection about nomination papers submitted beyond the prescribed hours of submission of nomination paper as per Form 1, noticed by the District Panchayat election officer and District Magistrate Southern. 3. The matter was brought to the notice of the District Panchayat election officer and District Swansea, seeking clarification and further. The District Panchayat South Vided Swansea instructed undersigned to follow the instruction of SEC or video number Swansea dated 17 June 23. That's a normal. No. In view of the instructions after prescribed time of filing nomination, as per Form 1 notified by the District Panchayat District of South is hereby rejected. My lord, kindly pardon me, my lord, for saying so. Since I have appeared in the matter, my learned friend was appearing before my Lord Justice Mantha. My Lord Justice Mantha. My lord, their case was that there was a complete obstruction and they could not file the nomination. My Lord Justice Mantha was pleased to direct us to give our explanation. My lord, on the last occasion, I appeared before Justice Mantha, and from my memory, just I tell your lordship, what has happened on that day. And my lord, this group, I have shown the video. I can show it to your lordship, the video even. This group, along with 2,500 persons, entered into the office of the video, forcefully said them to accept the nomination, almost on the gunpoint. The nomination paper under pressure of them. The nomination paper had to be received from 9 o'clock to 11 o'clock. The video was surrounded by the total mob. 2000 to 2500. This fact was placed before Justice, my Lord Justice Mantha. My Lord Justice Mantha, so far the law and order situation concerned, asked us to submit and file an affidavit within 15 days or 29. He is aware anyway, my Lord.
And CCTV footage.
And the CCTV footage also. So far the law and order situation is concerned, that is being taken care by one of the question is, my Lord, the rejection has been made on the ground that they have, this is the stand, this has been, the copy is not with me now. The video has also lost a complaint before with the officer in charge. The hooliganism which has been done by them after 8 o'clock. There were nomination papers had been filed after 8 o'clock, and this is the ground, my Lord. His scrutiny, she was not present in the scrutiny. What can be done?
So, is it at the scrutiny stage that the nomination was rejected?
Yes, yes. That's exactly I am telling you.
But then the submission is, I do not know what the fact is.
Yeah,
The
right.
submission of the petitioner is that after scrutiny, the name was appearing in the list.
No. But his submission is this. His names were even also 17th evening in the
Up to 20 years.
up
Till finally.
till final list is there. This is his case. Website is not within the statutory things. Whether the website has been corrected or not corrected, that's one of the matter. But the matter is whether the rejection has been done by the competent officer within the time of the scrutiny or not. But I am
Is the petitioner made aware that her nomination has been cancelled?
Milord, if she doesn't remain at the time of scrutiny, all has to remain present. If she doesn't remain present in a parliament election, Milord, I have to remain present, leaving aside all my jobs.
And at the time of filing nomination also, the candidate is required to remain present personally.
Personally, what has
At the
happened?
time of scrutiny also, the candidate is required to
Candidate
remain,
or his representative,
is
or his or
required-
her representative, or the election.
You say that nobody from the petitioner number 1 was present over there. Nobody. Nobody.
No one was there. My Lord, kindly see what has happened. Candidate has to remain present at the time of filing nomination. Nomination was given by force after 8:01 p.m.
I will require a copy of what you read out.
My Lord,
Rejection.
can I print? Can my
Yes,
junior
yes,
can
yes.
print it and give it to your Lord?
Yes, yes,
My Lord?
yes.
Just
yes,
kindly,
yes, yes.
excuse me, my Lord.
Yes, it's permissible. Yes,
In
yes.
fact, it is such a short point of time.
Yes.
That's the reason. My Lord, normally, I am not appearing. Since a Bhangor's matter, I appeared before Justice Mantha.
Very
My
well,
Lord, they
yes,
have
yes.
requested me, my Lord.
Hmm.
Therefore, my Lord, today, what I was submitting to your Lordship, let's say the dispute. Let's assume for the argument's sake. Let's assume for the argument's sake. This scrutiny rejection was bad. This since it is in the list, their names were there. Therefore, a presumption can be drawn. No, scrutiny, they were allowed. Let's do it. Therefore, it's a dispute. And it is an election dispute. Now, my Lord, whether it is required to be proved by way of evidence or not. My Lord, I will give this. Just excuse me, my Lord, print down. I will give you the printout, my Lord. This has happened. This has happened, my Lord. Therefore, my Lord, I respectfully submit to your Lordship, my Lord, I have referred to the 3 judgments, Purnaswamy's judgment, West Bengal State Election Commission's judgment, even the Hasanuzzaman's judgment. And my Lord, the very particularly, these sorts of allegations were there in the Supreme Court, the 2018 matter.
And also in the municipal election of...
And municipal election division bench also, my Lord, I have, Judge Sahib, this is copy.
No, that copy has not.
My Lord, I am, just, my Lord, I am, both the 2 copies. My Lord, these are my submissions, my Lord. My Lord, would your Lordships will continue with the matter, my Lord, or some break, or I don't know.
No breaks, because we have got an early rising today.
Oh, yes.
So many urgent
No,
matters.
my interest on nothing. One of the matter at 2 p.m. your Lordship has fixed it. That's
Yes,
the-
I'll continue.
Okay. Just for, don't take it others, my Lord.
Yes.
I needed 5 or 10 minutes time. That's the idea.
Go.
Deeply obliged to your Lordship. এই জজসাহেবকে দুটো তুমি দিয়ে দাও কি
That my senior is there, like, only to assist him. Let
Yes.
kindly, sir, kindly takes up page section 49 of the Election Act.
নতুন কিছু বলবি নাকি আমার পঞ্চায়েত একটা না ওইটা তো
Clause 6.
এটা নাম নেই এটা আমরা পড়লাম
Clause 6, 49-6.
49(6) পড়লাম
না, 49-6. এই অর্ডারটাই তো আমরা পড়ে শোনালাম
Yes.
ট্যাব থেকে।
that is the order.
Which section are you referring?
49 subsection 6
49(6). Scrutiny.
Scrutiny.
Kindly allow me to assist him.
Yes.
পেশ করো
Kindly similar clause 6.
Hmm.
The Panchayat returning officer shall endorse on each nomination paper his decision accepting or rejecting the same, and if the nomination paper is rejected, shall record in writing in brief statement of his reason for such rejection. Therefore, whatever is to endorsement or reason, the returning officer, he has to give it on the nomination paper itself and in presence of the parties. And we were present during scrutiny. There was no decision, and now the decision now they are producing in a separate sheet. Now this is they are inviting investigation once again. But why can I tell you, Lashim, on 21st, in another matter in the same constituency, we have approached this honorable court. Court has passed in order in presence of the state as well as the election officer, election commission. There was no such decision on that particular date. This particular sheet was prepared subsequently, and there was no endorsement made on the scrutiny nomination paper on the particular date. The entire thing was recorded in terms of the direction of the division bench, should have been recorded at least. That if they produce that recording, that will be in any event, this decision cannot be on a
But then tell me, if there are factual disputes, Mr. Bhattacharya, you also listen. If there are factual disputes, can these be gone into in the writ petition, or an election dispute will be the only remedy?
Lord, election dispute can be a remedy when there are stray cases, 1 or 2. But here the nomination process will not initiated with the intervention of court. Without the court being satisfied that these people were prevented, without given the police protection, they went to file the nomination. The scenario as it was there with the police protection is obvious. And this ground reality is so serious and so precarious. That's why these questions come. The nomination papers, without rejection, no factual determination is necessary. As per the requirement of law, he has to show that he had recorded his reasons on the date of election nomination. In absence thereof, everything is bad. And look, what is the basic principle of election? Why are they scared of participation? They should welcome that, yes, come and participate. If there are certain mistakes, it should not stand in the way. The foundation of election concept is being destroyed, and always is go before the election petition. This is not 1 or 2 individual. In MLA and MP elections, how many election petitions are there? Here, about more than 65,000-87,000 candidates. Amas chaos. To prevent that, the Reed Court, without being extraordinary power holder, would definitely intervene. I just give you also a reference of the cases. You must remember, the case would be cited when the Tamil Nadu government dismissed all its employees by stroke of a pen. Then the matter went up to the Supreme Court, High Court. High Court said, now go before the tribunal as per the State Administrative Tribunal Act. Now the Supreme Court said it is impossible that thousands of employees will go to the tribunal. The Reed Court should intervene. And Reed Court intervened under the special circumstances and will pass the order. Therefore, the extraordinary power has to be exercised in an extraordinary situation. That situation is before your lordship. And my lord is very correctly interfering to ensure that the election goes on. No selection, but election. That is the more
That's
fundamental.
correct. But new thing has been said now.
And one more thing,
Mulad,
that
And
in,
one another important thing, what Mr. Banerjee probably could not follow me. I said that if there is no election of the assembly and parliament, there is a constitutional crisis. No one can take care of that. But if the election is not held, president rules cannot be imposed. President rules can be imposed when there is a valid assembly, not beyond that. And that's why the court said there will be a constitutional crisis. But in the panchayat election, that though every 5 years they have to hold the election, but if it is not held or delayed, there is no
Correct.
crisis
very, very
that the
interesting
government
question.
under the Panchayat Act can take care of.
Mulad, very interesting question. Is the election is being held under the constitutional provisions? 243(o), the moment Milord chapter 9A has been amended under constitution, all the persons, Milord, even a panchayat member is holding a constitutional post. MLA is holding a constitutional post. MP is holding a constitutional post. It is within the constitutional scheme. Pre-1991, situation was something different. Now it's a constitutional crisis from the grassroots level. Whether Milord, in the vacuum, Milord, Indira Ragnam, what would be arrangement? That's a different thing. That's a different thing. But it is a vacuum. What would be done? What court will pass the order? That's a different aspect of the matter. From a plain and simple interpretation. Therefore, Milord, with great respect to Mr. Bhattacharya, he is much senior than me and very good friend of mine, and also one of the friend in also in the another house. That Milord, I'm sorry, I'm great respect. I disagree with Mr. Bhattacharya that this is not a constitutional post. It's a constitutional post, constitutional crisis. Maybe someone is. My Milord, kindly see that my Mr. Bhattacharya said so many these things. Milord, kindly see so many obstruction, etc., so many things have been done. Last election, before the Supreme Court, when the Supreme Court was being heard the matter, only 168 election petitions were filed.
Out
Correct.
of 1700 complaints.
Out of 1700 complaints. And my lord, here in this judgment, Mr. Bhattacharya's clients, I mean Communist Party of India Marxists, were given liberty to file election petition for 20,000 uncontested seats. But Mr. Bhattacharya's client, the CPM party, could not file a single petition in terms of the judgment of the Supreme Court. Therefore, it's very nice to say, my
Because
lord,
of the
this happened,
situation-
this has happened, this has happened, that is happened.
Because of your
Not only
situation,
Mr.
no
Yes,
petition to be
situation.
filed.
Your situation. Mr. Bhattacharya, kindly do not allow, do not speak something that where I will be compelled to open my mouth.
Please restrict the
Now,
submission
Milord,
with
this-
regard to
the-
this
the-
matter.
now-
We hardly have time.
Now,
in hand.
therefore, now, therefore, Milord, and see, in the writ petitions, is there any single averment?
That they were present.
They were present in at the time of scrutiny. Paragraph. Come. কোথায়? কোথায়?
in the middle, neither was any endorsement
presence
made on the
No, no.
the petition in
What?
terms of section 12.
No, kindly see, where is the averment? The petitioners and his agents
Yes,
or authorized persons?
yes,
We can't read.
they recorded
Wait
their
a-
presence by affixing their signature on the attendance sheet. In fact, neither the assistant panchayat returning officer nor any other person raised any objection at the time of scrutiny. Neither was any endorsement made on the nomination papers of the petitioner in terms of so-and-so rejecting the nomination paper. On contrary, the petitioner was informed that their nomination paper have been accepted.
No, no. কোথায়
Our-
acceptance টা কোথায়?
কোথায় রয়েছে?
What more I can say?
No, you were present and you have affixed the signature is the statement. The other persons may be remain present. The other persons may be remain present. The petitioners or their representatives were present and affixed the signature. Is this statement is there? Therefore, my lord, this is a question. My lord, is a disputed questions of fact. I must say to my lord. If he is having any grievance, rejection has already been made, and therefore, in this case, my lord, I don't know, my lord, whether what order has been passed by your lordships in other matter. I do not know. But the point is, my lord, once it has been rejected, let's assume it's an illegally rejected. Let's take his best case that illegally rejected. No reason is there, illegal things. Does it come within the ambit of the election dispute or not? If it comes within the ambit of the election dispute, then the writ court would not interfere. This is my humble submission. That's all. জোসেফকে দুটো কাগজ দিয়ে দাও প্লিজ এনেছো
Very well. Hearing is concluded. It will appear for orders on Monday.
Minute, I will give this later on.
Please do.
Minute, just 10 minutes.
The rejection, my lord, I'm handing over right now. The judgment is coming, my lord. I'll hand over to the
Molay Banerjee.
একটাই জোগাড় করেছি দিচ্ছি
হ্যাঁ মলয় ব্যানার্জি কি
মলয় ব্যানার্জি কপি ইয়েস জাজমেন্টের কপিটা
ও ইয়েস মলয় ব্যানার্জি জাজমেন্ট yes sir
I have the similar point that I argued yesterday.
no it's all right Malad, there I have this which matter
Bangor matter, same point.
no before that the other matters are there এই ওই ম্যাটারটা এটা
Item number 10 is similar matter.
কত নম্বর আছে ওই ম্যাটারটা
4 ভাঙর ইজ 4
আমি না আমারটা ওটা তো
একটা ক্যানিং আছে একটা ভাঙর আছে
ক্যানিংটা কত
ক্যানিংটা হচ্ছে 7
ওটা ব্রিফটাতে
ক্যানিং
না ভাঙর একটা ভাঙরটা ওটা তো
নেবে না এটা নেবে
This was item number 7. Which one is same? You said 10.
10
Same.
same Malad,
All
there
right.
also order has been passed rejection
Then I require the order.
order ওটা তো order দিয়ে
Item 10. Order in item 10. It will be called on. Please wait one by one. Item 8.
নাম কি মামলাটার নাম কি
Sheikh Qiamuddin.
here
The point is,
এটা কত
the petitioner was intimated about the rejection of his candidature from one of the constituency. He had originally made his, submitted his nomination for 2 constituencies. For both the constituencies,
এই
8 লেখা আছে
এখানে আমার অর্ডার দিয়ে আছে একটু জল দিতে বলুন তো Yes.
for both the constituencies, the nominations were accepted. It appears.
8 করছো কি 8 বলে may I hand over the 10 item number 10
It will be called on.
Called
Please
on.
do.
Now, Lordship, kindly come to directly page 26. This is the receipt of the documents given by the nomination paper for Mustadin's 1113. This is one constituency. And page 18, Lordship, another,
You are Sheikh Qiamuddin.
Sheikh Qiamuddin.
Yes.
He had submitted for 2 constituencies, nomination for
Right.
2 constituencies. Now, Lordship, he participated in the scrutiny process. Now, recently my learned friend, Mr. Ahmed, was showing one section to your Lordship, section 49, that where the purpose of the scrutiny and the order has to be written. Therefore, that scrutiny which was conducted on 17th, it should have been written, and summary rejection,
Should have been.
if his candidature was rejected
Yes.
on any ground, that should
Right.
have been reflected on that day
Alright.
itself.
Yes.
In view of section 49, I'll cite that.
Ah.
Now, on contrary, then once this was done on 17th, after that, I made a representation for withdrawal of my candidature for one of the 6, one of the constituency. This is on page 28. And this was, and it was ultimately withdrawn on, this was 17th, I intimated, and ultimately on 19th, kindly come to the impugned order, page 33. It was on 19/6/2023, 2 days after the scrutiny, his candidature was rejected by them. With reference to the above mentioned subject, this is to apprise,
But
I have
this is in
looked into
respect
the
of
matter.
only one constituency.
One
What
constituency.
about the other?
Other I have already withdrawn after the this
Oh, one you have withdrawn and the
Withdrawn.
other has been cancelled.
cancelled.
So you are out.
After the withdrawal, this was, so I was out. No
Why did you
documents were
withdraw
pending
from the other seat? You did not want to.
because there is a bar that I cannot contest from two constituencies.
Yes.
Initially, I have taken the nomination papers for two constituencies. I have filed the nominations with all documents. On 17th, there was no intimation given to me that whether it is rejected because everything was in order. On 19th, once I withdrawn the candidature on 17 by giving the letter, on 19 it says that your candidature is rejected on this ground. So it is basically, in my humble submission, a candidate becomes a candidate once his name are published in the final list of candidates in terms of section 50. Now, Lordship, kindly come to.
But then your name was never published.
My name was never published because 19th was the 20th was the date for the last date for the withdrawal, and that is a continuous process. Now, kindly come to section 49 and for 50, Lordship, I will read, and that will do my purpose, Lordship. Section 49, Lordship, says that scrutiny of nominations. I am on the clause 2. The Panchayat returning officer shall then examine the nomination papers and shall decide all objections which may be made to the nomination and may either on such objection or on his own motion after such summary inquiry, if any, as he thinks necessary, reject any nomination on any of the following grounds. Thereafter, the grounds are there that on the day fixed for the scrutiny of nomination, the candidates either is not qualified